You're watching Daybreak, reaching you live from the nation's capital in Abuja. And now we'll be going straight into our first discussion on the program. Now, how to institutionalize a fair, humane, accessible, and accountable justice sector in Nigeria has been the concern of the key stakeholders in the country's justice sector in recent times. Now, the judiciary, the other arms of government, civil society, international development partners, and other stakeholders in the sector have put in a lot of effort in this regard. For instance, the Nigeria Bar Association, in a bill it presented to the Constitution Review Committee at the National Assembly, made elaborate proposals for reform of the judicature provisions in the 1999 Constitution. The bill focuses, among other issues, on the related problems of proper budgeting and funding for the judiciary and the need to separate the administration of the courts from the administration of justice. Now, we'll be taking a look at this and more on the show this morning with a senior lawyer, Barrister Mainasara Umar Kogo, who is right here with us in the studio to talk about this. Good morning and welcome to Daybreak.
Good morning, Nigerians. Happy New Week.
All right. Yes. Well, welcome on the show. Now, recently there was this, summit, if we may use that, to usher in our discussion. Summit by the Nigerian Bar Association alongside other partners. The focus is to talk about the reforms that are needed in the judicial system. For instance, the issues of selecting of judges, the issues of funding for the judiciary and the welfare, of judges, and then also the issues of delay in the system. First, let's begin with the issue of selecting judges in the country, which was one of the major concerns raised, at that summit. A lot of people have said it's too porous. It's not rigorous, to ensure that only credible people, and people emerge based on merit and all of that. Itself, if you look at the Constitution and the processes in which the judges are appointed at the federal level by the Supreme Court in particular, for instance, is appointed by the President under the recommendation of the National Judicial Council and all of that. Other than that provision, we don't see anything else, that is required. All that is needed is that recommendation by the NJC and the final approval by the President, subject to the confirmation of the Senate, for instance. So people said issue of politicization, of the process.
Well,
what's your own comment?
Excuse me. It's not so much issue of politicization. All those things we are talking about are paradoxical. Paradoxically, you will see it as if we have standing rules and regulations. And it's not so much politics only. Going by the last list of the judges of the Federal High Court released, there were a lot of criticisms and accusations that children or those with affinity with the members of the upper bench are the ones appointed at the High Court level. So, but the point is that if you don't know the meaning of judicature, if you don't know the enormity of the responsibilities that is entrusted in a judge, if you don't know what is expected of a judge, then definitely speaking, you are bound to attach affinities in the processes of the appointment.
That's one of the issues I wanted to raise, the critical role that judges actually play.
Well, a judge should be somebody who is costumed to the culture, customs, character, and practices of the society first. You should be averagely more knowledgeable with greater number of the people. You should know the history, the demography, the sociology, and the economy and general social being of the society. If you are somebody who attaches three things to your spirit of mind, if you are somebody who is carried away by emotions, or if you are somebody who is a coward, or if you are somebody who is corrupt, These three are not qualified to be appointed judges. And the simplistic provisions in the Constitution are that a lawyer that is up to 10 years standing can become a high court judge or can become attorney general either of the state or of the federation. A lawyer of 12 years can become a court of appeal judge, and a lawyer of 15 years can be appointed a Supreme Court judge. He can be appointed straight ahead without the necessity of going through the ranks of progression in the judicature. But what we are seeing is a reverse of that. A lot of factors are coming into play when you come to the issue of the appointment of judges. A lot of political influences are being usurped rather than the dictates of the conscience of the judges. A lot of affinities, a lot of sentiments, a lot of considerations are being pumped into the machinery of judicature. And that is the reason why we can find it difficult. Judiciary or the judges that you are seeing are part and parcel of the society we are living. Section 15, subsection 5 of the Constitution says that it is mandatory on every state, state means every governmental officer, to fight all forms of corrupt practices and abuse of office. You are seeing infractions being perpetrated by judges at various times of our history, but no penalty, no sanction.
Yeah, people, some have equated the powers of a judge to that of, life and death. Someone who can actually decide the fate of a lot of people.
Yes.
And so if you look at that, and if you look at the requirement of, say, 10 years, 15 years, 12 years, is that enough really to,
that is what I'm saying.
Someone
what I'm saying is that it is so simplified in such a way that anybody who just meets the basic distinction, if you have the affinity with the powers that be, you can become a judge. That is what I'm saying. Character is never mentioned, even though it is part of the legal profession that you should be above board. Characters must be put into consideration. You understand? Your background, your history, your character, your type of associates, your degree of temperament. You understand? The type of people you associate with. All these kind of records have to be really examined. And your level of jurisprudential knowledge of the law, your ability to be workaholic type, to work all through the nights. How about your research acumen? All these are the factors that are supposed to be put into consideration. As a matter of fact, it is more important for you to be rigorous in selecting a judge than to be rigorous in selecting either a minister or a president or governor. Because
now,
the judge...
what are the processes that tests all of these things that you mentioned?
The process is the result we are getting.
Do we have any protest? Do we have any process, to determine, whether one has some of these elements that you
we are seeing them on our desk, on our table every day. Number one, the quality of conflicting judgments we are getting. Number two, the delay in delivery of the service, the delay in getting justice. Number three, the frivolous misuse of your umpire as a judge in awarding unnecessary interlocutory orders. Number four, the red tapeism we are seeing in the judicature, whereby if you file a case today in the Supreme Court, you hardly get it listed, you hardly get a date to start it within a period of 20 years.
So are you saying the
delay... And the inability to account for the humongous money being budgeted into the judiciary. All these are the results we are seeing.
So the delay we are seeing in dispensation of justice, is it because of the kind of judges we appoint?
And not only the kind of judges, including the kind of lawyers we are having. If a client comes before me, I should be able to advise him. Please go through alternative dispute resolutions and settle it out of court. I should be able to look into your face and tell you, I'm sorry, don't dispense your money on me. Don't waste your money. You don't have a good case. Because of this.
But the lawyers need money, isn't it?
No, I'm telling you, they look at their license or certificate to practice as a ticket to eat worldly meal. as a ticket to get whatever they want, under the cover of this hypocritical notion that a judge is not bound to refuse a brief. You are bound to refuse a brief. You are bound to advise the decision. That is the natural responsibility placed on you.
Okay, now, do we have any system in place at the moment that says, if you want to be a judge, you sit for this exam, you do this, the NJC will have to go through this or that or that? What are the processes?
No. There is nothing like examination. In those days, there used to be form you fill. From the form, they will be able to get the resume of your biodata, and they will be able to dish it out to the security agencies to scrutinize and find out. But nowadays, the system is that you should not even recommend yourself. You should not nominate yourself. Someone else will see the character and the quality in you and then make appropriate recommendation. And that is why in most cases you will see people with affinity with the judges are the ones that are eventually being appointed high court judges. You know? So it is the entirety of the legal practice, legal system that needs to be, what do I call it? Needs to be, I don't want to use the word panel, needs to be corrected. For example, if I am to suggest, the first thing is to suggest even we should don't put the use of wig and gown. We should take what is going on in the advanced countries. So that when you come, for example, a poor man from my village, coming to the court for the first time, seeing somebody in this type of costumes, it will, number one, intimidate him first. So the balance of justice between an illiterate and educated man has already been broken there. The balance of justice between somebody who is a poor man and a rich man should equally be this. This idea of, say, no matter how much offenses you have done, that you are adjudged to be free. I mean, it's only accusation until adjudged guilty by a competent court of law should be changed, so that it should be transformed into, whenever you commit any offense, we should now say, okay, Mr. Ilya Ayuba, these are the offenses that we are charging you, and these are the necessary sanctions that should befall you. Convince us as to the reasons why this punishment should not be applied to you. The onus should be placed on the accused, rather than the onus now that we have it on the person that is prosecuted, which in most cases you will discover that the person that will apprehend you, the person that will report you doing the offense is different. The one that will apprehend you is different. The one that will take your, what do you call it, notes, the one that will interrogate you is different. Okay. The one that will analyze and then come and prosecute you is different. Okay. So you, by the time something you commit and then you now attach it to say that whatever is it must be proved beyond reasonable doubt, and there is no yardstick to calibrate the reasonability of the doubt. The doubt of who? It is the doubt of the judge. You are coming into the person of the judge again.
Okay, another issue that has been contested over time is the issue of how independent is our judiciary. If you look at the process of, say, appointing the judge, for instance, automatically it looks like, you know, the judge, the appointment of a judge is in the hands of politicians. In this case, either the president or the governor of a state, you know, on the recommendations of the NJC, you know, and then, you know, the confirmation by the Senate in the case of a Supreme Court judge.
But to be sincere,
so, I mean, what's the chance that this person, after being appointed, you know, by the president or the governor, is not going to be,
to be fair, to be fair to politicians, this is the area I must give kudos to the politicians. To be fair to politicians, this is the area I will give kudos to the politicians. As much as possible, as much independence needed for the judiciary, they are getting it under the current dispensation. The government, the present government, is the one I can beat my chest and say doesn't interfere in activities of the judiciary.
Yes, that may not be the same for the next administration.
No, what I'm saying, generally, they have established a custom different from what is there in the Constitution. The custom of seniority lineage. If you, for example, go to the Supreme Court, the same applies to Court of Appeal, to Federal High Court, to State High Court. The number one judge is the Chief Judge. The number 2 is the most senior next to him. The number 3 is the most senior next to the second. It is in that order you see courtrooms. You understand? It is expected that whenever the CJN is not there, the second most senior will be the one, even though it's not a law, but it's almost automatically the tradition now. That tradition has been established. You are expected to have gone through the rigorous...
yes, but the problem with that, Mainasara, is
yes.
that if you do not have a law in place, it means you do not have a system.
Well, as far as I'm concerned...
what it means is that another person could come to that office who does not have consideration or regard for, you know, the tradition that you are
what I am
about.
saying is that, like,
so
people
how
like
do we
Justice,
ensure that there is, you know,
people like Justice Taslim Elias, there are so many of them that didn't pass through what do you call it, this seniority ranking of a thing. They are just, some are picked from the academic, some are picked from the outer bar, some are appointed like that. What I'm saying is that the judicature has NJC as a mechanism of entrenching discipline. That is one. It has NJC as a mechanism of giving recommendations regarding those to be appointed as judges. Apart from that, they have independence when it comes to fiscal independence, financial independence. They work out what they want as budgets. They are not subjected to any auditing. You understand? I've never seen any judge being penalized, especially the application of esprit de corps that they are doing. You hardly see any judge caught with any infraction, rarely given a severe penalty. In most cases, what they do is maybe they strip you of next promotion, or they deny you of next promotion, or probably they suspend you. That is all. But I don't see them really, I don't see any opening whereby the executive or the legislature intervenes so much in the judiciary. Something. Any problem you see with the judiciary is a problem internally engineered by them, or their inability to utilize the powers they have under the constitutional provisions given to them. Okay. If you take sections 230 down to 304, the judicature has gotten avalanche of humongous powers and authority to virtually decide on everything. So I do not believe that there is any interference or the decision. I must give credit to the democratic system we are operating from 1999 to date. They have tried as much as possible giving the due independence to the judiciary.
Okay, now talking about finances, in that summit, the Attorney General of the Federation, Malami, challenged the Nigerian judiciary to be open in its budget, and he pointed that government cannot determine if the judiciary's allocation is sufficient or not when its budget is shrouded in secrecy.
Yes, that is right. That is right. For example, nobody knows what is the budget of the judiciary. And apart from that, they are not subjecting themselves to auditing. Yet they are the ones, when somebody is enmeshed in fiscal infraction, that will be brought before them for them to declare him guilty or to declare him free. You understand? It's really contradictory. The judiciary, though the judiciary and the National Assembly too. The National Assembly too is not being subjected to auditing. You understand? Whatever they are doing, we don't see them. Look at the way they are even involving themselves in this, what do you call it, pardon and other things. And then constituency projects, which are essentially the responsibilities of the executive, and so many other things. So it's a case of every institution is trying to utilize its own technical avalanche to cover itself or to protect itself. That is the way they are doing it. The legislature is doing it, the executive too is doing it, the judiciary too is doing it, until we are really serious to cleansing the society and the system generally. Until we are prepared, the National Assembly is prepared to cleanse itself. The executive is prepared to cleanse itself. The judiciary is prepared to cleanse itself. Until we take the totality of the system of governance and really become serious in entrenching discipline, decorum, morality, ethics, and whatever, then will remain, all those things will remain theoretical.
Okay, you know, I understand that the whole idea, you know, behind putting these institutions under the first line charge, statutory agencies that enjoy statutory, I would say institutions that enjoy statutory transfers, is to ensure that they are not being manipulated, is to ensure that they have some level of autonomy or some level of independence in themselves. So, which is why you have the National Assembly enjoying that, and as well as the judiciary as well. Would you say that that is being abused, and that there's need maybe to now think about another law that will subject them to scrutiny in that regard?
Of course, it's in itself, I look at it as an instance of gross institutional injustice. Why is it that you don't want what you are applying on other people to be applied onto you? Why should it be so? You understand? Why it should be so? And that is the reason why we are not seeing the real dividends of the fight against corruption, or whatever you can call it, cascading down to the ground level. Because those that are supposed to inflict these things are being teleguided by some primordial considerations off in their brains. So we have to really be prepared to get the decent. And then the quality of the judges too matters, their integrity, their background. In those days, you used to see judges that delivers judgments that moves mountains. You will see judgments that jurisprudential decision of any judge statement when he reads it is incontestable, globally speaking. Nigeria has succeeded in producing world-class judges, world-class jurists that are the decision. But unfortunately, what we are seeing now, accusations of corruption, this and this and this, it is very, very important. If the judiciary cannot utilize the instrumentality of the NJC to be sanitizing itself, to be instilling ethics, discipline, decorum, and respect to the tenets of the institution, then they should be prepared to subject themselves. Unfortunately, where will you even go? It is still the judiciary.
Yeah, so the issue of discipline of the judiciary is left in the hands of discipline of judges. It's left in the hand of the NJC. So is that why we have not been able to deal with the issues of corruption, in the sense that has the NJC not been able to discipline its...
No, on the issue of corruption, there are many things wrong. It's beyond that. On the issue of corruption, it's beyond that. It's beyond that. When there are humongous accusations against those that are administering the institutions of corruption, and you didn't do anything, what do you expect? When all the past leaders of the anti-corruption agencies, from the first one to the last one, were booted out of office on ground of corruption accusations, and none of them has been prosecuted up to now, what do you expect? When there are incidents of what do you call it, accumulation of recovered assets and recovered money, and these things are nowhere to be found, what do you expect? In a situation whereby you don't have a dedicated anti-corruption court, we have said it repeatedly, that establish an anti-corruption court, special anti-corruption court. Get people that are above board, people that are outside the current judicature system, people that are prepared to step on toes, people that are more look at it as beacon of service to God, people that are prepared to penalize, people that are prepared to offend, people that have the integrity and what it takes, that love this country more than loving their lives. Get this type of people, make it a court of summary trial, so that any case that comes, it should be a maximum of, say, 4-6 weeks for them to dispense justice. Devoid of all technicalities, establish anti-corruption code, and then give it avalanche of... For example, there is this code. There's this code that has power to even penalize judges, and even the president, from president to everybody. The Code of Conduct Tribunal, but it has become important now.
Okay, we're going to get right back to the discussion quickly after this timeout. Please stay. All right, welcome back. If you are just joining us, this is Daybreak on Trust Television, and we are discussing judicial reform with a senior lawyer, Barrister Mainasara Umar Kogo, here in the studio with us. Now, Barrister, I'm really keen, about the slow pace of dispensation of justice, and
yes.
You earlier pointed out the quality of judges that we have. But apart from the quality of judges that we have, what really is responsible for this slow pace?
Well, there are other reasons behind that. Number one, the quality of the lawyers that are appearing. There are lawyers that will prepare to win cases on the altar of technicalities rather than the substance of the law. So you'll discover that even though the Administration of Criminal Justice Act has restricted this interlocutory appeals to only 3 in order to speed you up. But you will discover that there are other technical ways they will bring to keep delaying the matters. That is one. Number 2, lack of modern tools. I expect that in our courts there should be these converters. Converters, in other words, what you say in English will automatically be converted into a print material, so as to save the judges the excesses of energy of writing every word you pronounce. And then number 3, inadequacy of the courts. Let me give you, for example, the Supreme Court. How many courtrooms the Supreme Court has? Just about 3 courtrooms. All the appeals from the Court of Appeal, all the appeals from the about 1,000 high courts are going there. So you discover that the congestion of the cases are there in so much that when you file a case today, before your case can even be given a date, because there are some supervening cases that will come, politically related cases, for example, cases that are statutory bound, say it must be finished within so period, or cases that are involving the government, you understand.
Okay.
Those cases, those other ones will now kept delayed. So I expect like the Supreme Court should be unbundled in either of 2 ways. The first way is that you can create judicial divisions of the Supreme Court, for example, as a way to reduce the traffic of cases. There is Supreme Court in Port Harcourt, Supreme Court in Lagos, Supreme Court in Kano, Supreme Court in Abuja, something like that, like the way we have it like the Court of Appeal. The second way is that professionalize the court system at the Supreme Court level. Let there be Supreme Court of Criminal Matters, Supreme Court of Constitutional Matters, Supreme Court of Commercial Matters, Supreme Court of Marriage and Divorce, Supreme Court of Land Matters, in such a way that you have these things. If your case relates to this, the Chief Justice of the Federation will just assign it to the relevant court, where there are dedicated judges, increase the number of the judges, and doing it that way will facilitate speedy dispensation of justice.
Okay. All right. Well, I mean, we've said that over
and
again,
there are other things. There are albatross.
Let's
there
get
are
other perspectives.
There are some fundamental things.
We'll join Sam Kagbo virtually.
Okay.
Who is also going to chip in on this.
There are some fundamental bottlenecks that it is important we change them if we really mean justice for common man.
Okay.
There are 3 of them.
All right. Let's connect with Sam Kagbo now as I get perspectives on this same issue. Hello, good morning, and welcome to Daybreak.
Good morning, and thank you for having me this morning.
All right, well, let's get your own perspective on this discussion. I mean, the issues raised in the recent NBA summit, part of them, the issues of selection of judges, the issues of welfare and funding of the judiciary, and of course, the issue of delay in the justice system. So, in your own perspectives, with regards to the issue of delay in the justice system, it appears that we do not have enough court systems to deal with the humongous cases that we have, in our hands. Do you buy that idea?
Yes, I do. But before I go into that, let me say what the lawyers say. Let me pass across a caveat or a sort of a cautionary statement, and that is as regards to the what I would call, with respect, the ritualization of blames and wrong ascriptions. The judiciary, of course, is an arm of government, but it's not entirely dependent and self-sustaining. It is entirely dependent, and it works with the executive mostly for it to be effective, because most of the administrative aspect of the job of the judiciary is facilitated by the executive. And where the executive is lacking, that in itself affects directly the effectiveness or functionality of the judiciary. Yes, the judiciary can be more accountable, more transparent, but looking at the three arms of government, I think that it is the most transparent, it is the most accountable, it is the most sensitive to the needs of the public, and of course, the elite aspect of the three arms of government. It is not true that character is not a primary requirement for appointment into the judiciary. It is at the base of the requirement, because that's the reason why you have the layers of the appointing process. First, with the recommendations. The recommendations and letters that go out, or press releases that are made by the NJC requiring recommendations, speaks directly to the character of the person to be recommended. After character, you also have that of qualification. It is only the judiciary that requires not just a law degree and a call to the bar, but a post-call experience of a minimum of 10 years for the correct. All of these are not just thrown in the air. These are processes that are meant for the public to be involved in, because once recommendations are made and names are published, every individual, not just lawyers, is given the opportunity to make an input, and that is to react to the recommendation of the persons that are been recommended for appointment into the judiciary. But sometimes we, as members of the public, would always want people to do our job. And when things go wrong, we turn around to say, oh, we blame others. But the appointment process of the judiciary, to me, is the most rigorous, and it's better than most developed countries. In America, for the federal courts, technically, a president can appoint a carpenter because there is no qualification requirement. But here, those requirements are there. But coming back now to the issue of the congestion in the court system, I agree entirely with the gentleman, your guest in the studio, that a lot has to be done, because justice in itself is murdered when it's delayed to the point that even the parties themselves are wear out by the process. If you would need to have the patience and time, energy, and the concentration on the case for about 20 years before you can get justice, definitely that is in itself injustice. So there is a lot to be done. But what needs to be put in place is not just things or initiatives that are to come from the judiciary itself. It has to start with the legislator and the executive themselves. Let them take this arm of government as serious as it should be, and let it be finance Without the necessary finance, you can have the number of courts that are required. Without the necessary finance, you can't have the number of judges that you require. And to me, I have had the opportunity of having cases at the ECOWAS court. I was in Bamako, where the court sat for my case. You could see that their system is sensitive enough to allow the participation of even assessors. And it's what we call SANS technicality. There is nothing like technicalities in the ECOWAS court proceedings. Once you have filed your papers, once you've submitted documents, there is no need for you to go and start defending those documents. They are taken in as part of the process. The next thing you do, you go and make your submissions. And the next sitting is you have a judgment. But here, the entire process is swallowed and immersed in technicalities, so much so that the parties themselves, who are most time laymen, are removed from the process and now have to depend entirely on their lawyers, which shouldn't be the case. The lawyer, if for anything, is just an agent. It shouldn't be the case of what? The tail wagging the dog. But that is what our system has turned the justice system into. You find most of the time before you go to the panel of the conflict that is presented by the parties to the court, the time is spent entirely on what I would call the imposition of the judicial process itself, technicalities. That is something that the legislature can look into. That is something that the head of the judicial system itself would have to look into. If we take away technicalities from the justice system, perhaps we may be getting nearer to the people and we may also get their contribution into what we do. But for now, because the entire system is what I will call esoteric, the public is removed away from it, and we are left as lawyers and judges to grapple with our own problems without the sympathy and empathy of the public. But that is not necessary for us to have what?
You said quite a lot.
Justice system.
You said quite a lot, and I was going to take on the first issue you raised, about the fact that character is a major factor that is being considered in, the selection of judges in the country. But that seemed to be going into the direction of a contrary view expressed by the vice president, who himself is a professor of law, and the NBA president himself, who also admitted that the process is porous and that rigorous process that needs to be, followed through is not being followed through. It's mainly shrouded, in secrecy, and is, based on affiliation with the powers that be, political affiliation, nepotism, and the likes. If you look at the caliber of judges that are being appointed in recent times. So how do you explain, some of the lapses that we see in our judicial processes today, if the issue of character has been dealt with from the beginning?
You see, I think the aspect of the blame game. The MBA as a body, and like I've always said, the profession is ours. The judges, yes, they are lawyers, but they are not part of our profession, strictly speaking, although they are lawyers. And of course, they come from within us. When we have the opportunity at the appointing stage to lend our voice and put out ourselves to ensure that the system is not corrupted, the system is not abused, we look the other way. We expect miracles to happen. But we forget that the system itself is recruiting people from among us, and the recruiters themselves are from among us. We don't lend ourselves and put out ourselves at the right time to ensure that the system is not sidestepped and the system is not skewed in favor of what? The appointers. That is why it's not coincidental that at the end of the day, there is hardly any new appointment or new appointed judges that is not related to what? Perhaps an
Okay, well,
appellate
I was saying that, I mean,
justice.
if for
Yes.
instance, the NBA is there, what role does the NBA has, you know, in the appointment of judges? I thought that that's taken care of by the NJC. So how is the NBA supposed to come in this instance?
It's in the participation in the process. You see, there are layers. The first layer is the job of the Judicial Commission. Every state has its own, and the federation has its own. The Judicial Commission itself is nearer to the people, and it's the one that puts out the releases for recommendation and gives you the criteria of the sort of judges they are looking for and asks you to make your own input. It is at that stage that you can write your own memo. When you see somebody that you know is of a funny character being recommended, it is at that stage because what? It is expected that the NJC is blind to the process. It's only administrative. So when people are brought to the NJC, to the Judicial Commission as nominees, it only passes through those nominations to the NJC. But if you
Who
as
is
a
responsible
body,
for scrutinizing? Are you with me, Mr. Sam Kagbo?
yes,
Who is responsible for
yes,
scrutinizing, you know, and testing the characters of judges to verify that they are indeed qualified to take on the responsibility of being a judge? Who scrutinizes? What tests do they go through?
the public. The public. When you talk about character, I would rather say reputation here than character, because character is innate and sometimes it's situational. But the reputation is there in the public. And there is a correlation between character and reputation, though not sometimes coincidental. You, as a practicing lawyer or the public, the person appointed is coming from within a community. That community should know the reputation of that person, should know who that person is. If it's somebody who, in his practicing time, is somebody of a very questionable character, it is your responsibility, your civic responsibility, to lend your voice to the process by saying, no, this person, I know him for who he is, and therefore not fit for that position. The NJC cannot do that because at the end of the day, they will always sit over papers and credentials, recommendations, and put them against the law and come out with
Mainasara
what?
here
Their own recommendation
in the
to
studio
the president or
to also weigh in on this. All right, well, let's, I mean, you've heard all that Sam Kagbo has said.
Yes.
You know, you have probably one or two reactions to some of the things that he talked about.
Well, I commend him. He is my professional brother, and we have esprit de corps. We don't criticize our own selves. He's right. Whatever he said, I absolutely agree with him. But what I would like to add is that if we want to make the legal system better, there are certain things that should be adjusted. One of them is this veil that is called, what do you call it? nolle prosequi. That is, Attorney General is entitled to the power to discontinue any case at any level, especially cases involving states. He has no right regarding civil cases, but for cases involving states, he has the right to really go at any level and say, I enter nolle prosequi on this case. In other words, this case ends. No matter how much offense you are perceiving the accused person has committed against the government or against the entire 210 million Nigerians, once he enters it, I stop the case, that ends. You are not to ask him any question. So that one, I look at it as an aberration when you're talking about natural justice and equity. The second one has to do with immunity clause. There is no reason why Their Excellency should be granted immunities. If there is equality before the law, then why should you say somebody should be immune?
I mean, until when he is out of office. That's the provision, isn't it?
That is the provision, but there is nothing like until when he is out of office. It says that governor and deputy president and vice president are immune from all criminal prosecutions.
During the time of being in office.
When he is not in office, he is no more a governor now. He is no more a president. He is no governor, he is no more president.
Yes, so, but matters can be brought to court.
What I mean is that, like you and I, if we are having cases, once we are arraigned, our lawyers will be the ones to continue going. So why can't they be arraigned and then they ask their lawyers to continue going to defend them while they are in office? So I don't see the excuse to say that it will distract them from. I don't see that. Because the justice is being delayed. And justice delayed is justice denied. So it is important we remove that veil. The third one that I think should be removed from our judicial norms is that this idea of prerogative of mercy. Somebody has been convicted, death sentence, or life imprisonment, or 70 years imprisonment, or whatever terms of imprisonment. You now use the particular pronouncement during one ceremony and say, I have granted state pardon to you, to this. That automatically sets you free. So there are instances whereby it is not the judiciary that sets you free. But the mechanism we have implanted in our constitution sets you free or gives you cover. So those things should be removed.
Okay, now before we leave, end the discussion, that when we are talking about the delay of justice system in the country, there's this provision that lawyers have raised as a problem, in the sense that when judges are being transferred from or promoted from a particular court to another court, that case that they are dealing with automatically begins from afresh.
Yes.
When the Administration of Criminal Justice Act was amended, that was addressed. But again, we are now understanding that the Constitution overrides the Administration of Criminal Justice Act.
Sections 1 and 2 of the Constitution says that any law that is in conflict with the Constitution is null.
So how do we reconcile
to the extent of its content? The position of the law prevails. The position of the Constitution prevails over any other law. So those are some of the technical problems you have that can mar the implementation of the Administration of Criminal Justice Act.
So it's not enough to amend some of the laws that we are
working with. No, if you want to amend, that is the mistake normally the National Assembly is making. If there are fundamental mechanisms within the Constitution, and there are establishments of institutions outside the Constitution, for example, EFCC Act, Code of Conduct Bureau and Tribunal Act, ICPC Act, for example, it is not enough just for you to amend part of their acts without correspondingly implanting it in the Constitution. Otherwise, by the time those new corrections you have brought in the Act conflicts with what the Constitution says, whatever the Constitution says prevails over, and you will end up doing empty amendment there, because it cannot have the blessings of the day, because it is in conflict with the Constitution. So the important thing is, holistically, we should review sections 230 to 304 that talks about the powers under Chapter 6 of the Constitution regarding the powers of the judicature. Okay. Generally, it requires serious...
Let's get final thoughts from Sam Kagbo, who is joining us virtually. Well, apparently the issue of delay in the justice system is a constitutional matter, isn't it? It's a fundamental matter in our laws. So it appears that some lawyers have mastered the act of taking advantage of the loopholes in our laws, you know, to drag matters and all of that. How do we deal with that?
Yeah, that's part of the system that in itself the vice president has repeatedly asked lawyers to look into. Because like I said, you know, the ascription of blame sometimes in itself is injurious to the truthfulness of what is happening. Lawyers sometimes believe or try to remove themselves from responsibility, and they think that they are only responsible to their clients who pays them. That is a fundamental flaw, both jurisprudentially and as the basis of your call to the bar. A lawyer is first and foremost a disciple of the temple of justice, and that is the foundation of every society. So I would say, if I were in a position, and I think without boasting, I have done my bit in that regard, because I am one of the 2 people in this country who pioneered alternative dispute resolution, and that is to reduce the load of the court and allow the parties themselves to process their own disputes, so that conflicts can be decided quicker and finally, without having to go through the wrongs of the judicial system itself. I am also, and I've also advocated, let us start the panel system. The Constitution did not prevent high courts from being paneled by 2-3 people. So that if you have 3 people panel and one has the fortune of being appointed higher bench, the other 2 can process the judgment, ask for that other person's concurrence or otherwise, and thereby you don't longer have to come and start de novo, afresh.
All right.
This could be done.
Thank you, Mr. Sam. Unfortunately, because of time, we have to end the discussion here. At this point, we appreciate your thoughts on the program this morning. Finally, we'll get your concluding thoughts.
Yes, my concluding something is that
specifically with the issue of, you know, the confidence, public confidence on the judiciary and its implication. You know, there are those that have said there's a correlation between, you know, driving foreign investments to Nigeria because of the perception that people have about our justice system. So, public confidence on the judiciary, how is that implicated?
Well, we have to tell ourselves the truth. We have to tell ourselves the truth. The confidence in the judiciary system of Nigeria is seriously very low. We have to do a lot to rebuild the confidence, and nobody will do it for us. We are the ones to do it. The lawyers are the ones to do it. The judges are the ones to do it. Remove the politicians aside. The lawyers and the judges, the onus is on us. The character of our lawyers in the courts, in the practice, demands a lot of review, demands a lot of the need for you to inject more in terms of better characters in the way we do practice. We have to really take the custodianship of the practice as a whole, not to think of it from the angle of just being hired. Whosoever hires you, you must win his case at all costs through all the this. No, we should, like my brother said, consider ourselves as ministers in the temple of justice to first of all say the truth to whosoever meet us. You can win this case, you cannot win this case. I advise you go and settle it out of court. Let us put ourselves the spirit that we are judges in the first and foremost, and then besides, the judges are normally picked from us, so we have to the greater responsibility. 40 to 70% of the responsibility is on the lawyers, especially the senior lawyers, the senior advocates. I must say it very well that the senior advocates need to be leading by example. They really need to lead by example so that other members of the bar will keep following them. And then the judges too. The judges, it is very, very important. It is fundamental we review the processes of recruitment of our judges. We must review the processes of recruitment of judges. If the perception against the criticisms of favoritism and other things are to be watered down, we must review the distance and increase the standard, the quality, the standard, the technical rigorness, and then the qualifications and the experience, the morality aspect of it. The morality standard should be paramount when you talk to the issue of recruitment of any judge. The judiciary should really be very serious about it. The lawyers should be very serious, and as well the appointment of the senior advocates of Nigeria. Okay. We need to review those type of things. There are so many people that have been appointed.
Okay, Mr. Mainasara.
Okay.
Unfortunately, I have to interject, yes, because of our time. Thank you so much for coming on Daybreak this morning and sharing your thoughts with us. We appreciate that.
Thank you. Thank you.